For admission, item number 16.
Instruction. So by notification, 2016. Disposal budget.
This shows up. Here, where is the notification of the government? Page number
30 also.
30.
30.
Annexure E.
Yes.
Okay. They are still in service
Yes, yes.
and they belongs to which class? 3 or class 4?
Class.
Class 3
Yes. Teachers.
teachers.
Yes. Graduate teachers.
And you refer to which provision?
This. Yes, the notification, the same notification.
Same notification.
Yes.
Okay. Twenty-ninth of January 2016. Okay. Okay. Okay, we'll pass the necessary.
Yes.
order. Yes.
Mr. Worship,
Mm,
Worship, here, my case is very simple,
Mm.
and this matter is also very simple.
mm,
But unfortunately, the petitioner extraneously taken a lot of steps. But my affidavit
mm,
filed on 19/6/2024,
mm,
Annexure 1. Annexure 1 is the application for allotment of common water, dated 27/2/1998.
Mm.
So as submitted for the limit petitioner council,
Mm.
the applicant was in the department, and because of by virtue of the post, he was allotted that particular common water.
mm,
So that is annexure 1 to
mm,
my affidavit in opposition.
mm,
Then annexure 2 is a allotment order dated 27/5/1998. That water was allotted to him.
mm,
Then, Your Lordship, again, I just want to rely on the specific documents
mm,
which were annexed to the affidavit.
mm,
Your Lordship, here, there are so many things happened during the lifetime. My annexure 10,
mm,
that is apology dated 29/2007. Annexure 10, that is page 31 to 32.
mm,
Lordship,
mm,
the petitioner himself, he very clearly that page 32 is a dead copy.
mm,
There is a application of the petitioner
mm,
to the Principal Secretary, Urban Development Department,
mm,
County of Nagaland, subject tender of apology, with reference to the subject cited above. I have the honor to state the following few lines for favor of kind conservation and sympathetic action. But I have been working as Secretary Development Authority in Nagaland since 2006. After I had endorsed to the Development Authority Timako, the Department of Urban Development issued an order to vacate the quarter at Tanmari. So that quarter is which is putting in the presentation.
mm,
That's a quarter. Since I have applied for upgradation of my post to additional chief town planner, I was in the hope of coming back soon. That is why I did not vacate the quarter on time, which I should have not done. The mistake happened rectified and in compliance of the order, I have vacated the quarter. Meanwhile, I have been directed to relieve from the Secretary of Town till further order, white orders and such, dated Kohima, 23rd April 2007. During the process of trying to restructure development authority in Nagaland, there has been omission and commission on my part, and I did not consult my senior officer in decision making, which I highly regret. Now I tender my apology and swear that in future I shall not repeat the same and work only within the above vested on me. I therefore request you to kindly consider my case on humanitarian ground and send back to the development authority so that I can carry on the ongoing project and complete within the schedule of time, or cross-responsibility with Zetimu, as he is also overburdened to local of the town and Supa, which are located at two different districts and for which lack of kindness and remind I will grateful to Lordship. I can, in connection with this, I would like to take your Lordship to the annexure 10. The copy is annexure page 34. Regarding here, the petitioner himself during his lifetime after retirement, he himself indicated regarding the position and occupation of the quarter.
mm,
So I will be allowed to read out this
mm,
annexure 10.
mm,
Let me read out from page 34. That's the back first.
mm,
To the Chief Town Planner Nagaland Kohima, regarding land settlement and allotment of water. Sir, with reference to our discussion on the subject cited above, I have the honor to state the following and clarify once for all the matters relating to issue of land and allotment of water, numbers and such at Chanmari Kohima. That the unresigned have been transferred to town as secretary and senior town planner Timapur in July 2006. Consequently, I have been asked to vacate the quarter. However, in the middle of the year, it was not possible for me to transfer my family. Therefore, I have informed the authority that I would like to construct my building there and keep my family. This has been objected by the authority and pointed out there was illegal transaction. As such, I have vacated the quarter and occupied the designated security quarter of Development Authority Nagaland at Dimapur and submitted a tender apology to the principal secretary dated 20 September 2007.
Hmm.
On 24/4/2007, some identified person barged into the residence at Dimapur and harassed me. The undersigned reported verbally to Honorable Minister on 25th April 2007 to transfer me to Suta. However, due to complaint of two staff of town, I have been relieved from the security town and inquiry constituted and I continue to stay in town quarter at Dimapur. However, the chairman town ordered me to hand over the quarter while it is leaders and such dated 27 September 2007. This is a clear indication that chairman is against my position. Post impact to town by on the midnight 25 October 2007, some identified person against barged into the quarter where I was living with the members of family and harassed me two of my boys. Consequently, I have submitted a representation to the Honorable Minister to cross transfer to Sudan. Page 35. The undersigned personally inquired from Zamtimu whether he is likely to occupy whether he is likely to occupy the quarter at January on 26 October 2007. And he told me that he did not occupy the quarter as he is living comfortably in his house at Forest Colony. Therefore, I have occupied the quarter as there was no place to keep my family and my life was in danger. At this juncture, I entitled legal place to cancel the land transaction and protect the quarter from further encroachment by a private individual because I am transferred to Sudan. I am going to stay there till retirement. Well, I may not settle at Kohima after retirement. As such, I have decided not to be penny wise and born foolish. I therefore request you to pardon me for all troubles I have brought to you during the period under report and transfer me to Suda and reallot me the quarter henceforth. I swear in the name of God that I shall walk faithfully under you and strengthen your hands in the administration as well as in the successful implementation of the various scheme in the department as you have also need the helping hand of a senior officer and for potential judgment I remain ever grateful. So, Lordship, this is about the regarding this water at January, now which is a supplemental petition. It was somewhere, not reachable, but it was submitted somewhere on 31st October 2007. So, Lordship here, because of his boss, he got this allotment that subject quarter, common quarter was allotted to him. And throughout his service, even he was transferred away from Kohima, he was trying to again regain the quarter. And till 2007, he have been upholding that it is a common quarter. So the petitioner was retired on the 31st August 2018. So after the retirement, the Lordship here, by the pleading of the petitioner and the contention of the petition, it is very clearly reveals that he was tempted to retain the quarter. And now the question was common quarter. And now in the present petition, the petitioner brought it. No, the land was purchased somewhere in the 2015 from the original landowner. So there is a creation, that is an external step taken by the petitioner in order to hold back the quarter which was allotted to him in the year 1998. So it is very clear whether the petitioner was a landholder or he was a possessor of the common quarter. Now the supplementary is only the common quarter, and quarter was built on the land acquired during the petition, the period. It was not built in the air, it was not hanging. It was located somewhere in January, which was inherited by the governor of Nagaland from the British India. So when the land was, there are some portion of land in Kohima, which was inherited by the government of Nagaland after the attainment of the statute from the British India. So there, the acquisition of land, do says it was not, because by itself, it has come to the hands of the government of Nagaland. So that particular portion, it was inherited from the British India government. So there, if the honorable court insists, I am ready to produce the documents. But the thing is here, it is not a state government to prove the position of the land. It is our land, and because of which we have constructed government quarter. And prior to the posting of the petitioner, again, the quarter was there. He occupied because by virtue of his promotion, he got his allowance. He on his application, he was allowed to occupy during his service life. He enjoyed that government quarter allotted by the department. And now on retirement, now he is claiming that not quarter, the land on which the building was constructed. So we can see, we can presume that they might not be petitioner here. If the land was purchased by him, then how he applied? And land is not there, then how the government quarter was there before his allotment, before the allotment of that particular quarter to the petitioner, he was already there. Government quarter was there, and because of which he applied sometime in the year 1998. He got promoted and he was entitled to get the government quarter, for which he was entitled, for which the government quarter was allotted. And now, after retirement from the service, and now the question of land, the question of ownership accounts, those question and acquisition also, those are not applicable in this case, because it is a question of government quarter. He happened to enjoy the government quarter during his lifetime, and now he is bringing the question of the ownership of the land. And your lordship, his apology and his letter dated 31st October 2007, during his lifetime. And now they sell it, which is not registered at all, purported to have registered sometime in 2015. So, if the
What is
petitioner-
the value of the land shown in the sell deed?
Yes. As per the sale deed, the area of the land is just for 3 lots.
Mr. Iralo, what is the value of the land?
No, it's not mentioned in the sale deed.
In the sell deed, it has not been mentioned.
Only the boundary, but the area is not mentioned.
The consideration is 3 lakhs
3 lakhs.
Area
It is there in the
on the sale.
sell deed, 3 lakhs.
75 feet into 50 feet. Lordship. Now the subject matter, the people is pending before the honorable court. So if the petitioner, if he contended that and asserted, if he really purchased and that purchase is affected under the provision of law, then what is the registration? Something is not registered. And there is a law in the state of Nagaland for registration of the deed as per the document registration act. So there's only a documents. Actually, it is not accepted unless it is registered under the provision of law. So it is not registered, but that provision said it issues 75 into 50 feet. That is the area of the land. But your lordship here, now petitioner wants to complicate. You want to complicate to that other side. Because the land law is very complicated in the state of Nagaland. Now they are coming from the land side. But the question here, after retirement, they should have vacated the common quarter. But it was not vacated. So because of which the provision of law, reliable provision of law was applied, and we have issued an eviction notice to the petitioner. And now as of when we have approached the commitment authority to issue the eviction order against the petitioner. Now the petitioner is bringing to the call to the authority that he has purchased the land somewhere in 2015.
Hmm.
He said, it seems I'm going to the pleading and the condition of the petition. It seems it's all up to top. Then if that is so, then way back in the 2007, how the petitioner made his request to the
Hmm.
government. So, Lordship, my prayer, the present petition is that this petition is not applicable and this case is not deserved to be remanded to the civil judge, civil court. Because the act of the petition itself, it is manifested by the contents of the petition itself. Very important. The master, he has apologized and he also retained the quarter. And after the retirement, he is claiming not the quarter. Now he is pulling the land on which the building is standing. So the petition itself will infer something beyond the preemptive petition. So my humble petition is the intermotor will be vacated and this petition is highly deserved to be rejected. That is my submission.
Yes, any reply?
Only be repeating myself. Regarding the sale deed, there is no question of it being registered. This is, I also includes, the Supreme Court, where it says it's the intention for, so far as the conveyances pertaining to, sale deeds which are not registered, it is the intention of the vendor, if he has fully surrendered the title, for these are matters of trial, but if you lordship may currently have the last authority in the compilation which are
No, there is already this, there is provision in the Registration Act that when the value of the property is above 100, it has to be registered compulsorily. Then
lordship may have 1994 SCC.
can the decision of the Supreme Court override the provision of law or act?
No. What I mean to say is, certain instruments are not registered, no doubt. Right. Now, in this decision at paragraph 10, the Supreme Court has explained the position. He has no doubt it will require registration, but even for a deal of
Yes, what is stated in paragraph number 10?
Paragraph 10, 1994 SCC 706 discussed on the. Should I read out?
1994.
Yes, 1990.
Oh, 1990. Okay. 4 SSA. Okay. Paragraph number 10.
Paragraph 10.
Yes. In the case of
an executory contract of sale. Now this is regarding the sale deed, where the transferee is put in possession of the property in pursuance to the agreement of sale, and where the parties contemplate the execution of a regular registered sale deed, the animus of the purchaser throughout is that he is in possession of the property belonging to the vendor, and that the former's title has to be perfected by a duly executed registered deed of sale, under which the vendor has to pass on and convey his title. The purchaser's possession in such cases is of a derivative character and in clear recognition of and in acknowledgement of the title of the vendor. Now, this is the question. The position is different in the case where, in pursuant to an oral transfer or a deed of transfer not registered, the owner of the property transfers the property and puts the transferee in possession with a clear animus and on a distinct understanding that from the time onwards, he shall have no right of title to the property. In such a case, the owner of the property does not retain any vestige of right in regard to the property, and his mental attitude towards the property is that it has ceased to belong to him altogether. The transferee, after getting into possession, retains the same with a clean animus that he has become the absolute owner of the property, and in complete negation of any right or title to transfer, his enjoyment is solely as owner in his right, and not derivatively or in recognition of the title of any person. So far as the vendor is concerned, both in mind and in actual conduct, there is a total divestiture of all his right, title, and interest in the property. So there's a distinction for deeds, for conveyancing which are not registered. It's the intention that applies, the animus In this case, I already submitted that the vendors, the original landowners, they sought queries whether their lands were acquired. There was no response to the effect stating that it was acquired. Therefore, they could sold the land on two occasions,
Mm,
which I refrain from repeating it.
mm.
I will make the submission of the letter to UG with the effect that the quarter, it goes to the effect that quarter is being segregated from the land, please cannot be. They have to show that the land belongs to the government. Now, merely because of the existence of the quarter, no presumption of ownership can be laid on the government.
So let us see the impugn order.
Yes.
Is it Annexure 20?
Yes, this photo will be already uploaded.
Yes, the first impugn order is at
Page 26.
page 26.
Family.
Page 26. So this is notice, in
Yeah.
fact,
Yes.
notice, and when the order, first order was passed,
Page P21. I'm sorry.
page number
Connection P6.
P6.
That will be at page 36. This is the eviction notice. We're sorry to show post notice. There are
36. Director, where is the impugn order?
the authority spotted, so lordship that pointed out, page 69 and it's P20.
Page number?
Athlete authority. Athlete authorities orders.
No. No. Okay. This is the order,
Yes.
one of the impugn order.
Yes.
P6.
P6. Main. Eviction
Main
notice.
order, eviction order.
Yes.
Order. Okay. Thereafter, the appellate authority order.
Yes.
It is page
Page 69.
69.
And followed by, the athlete authorities order is also quite vague in nature. Because after after setting aside my appeal, it directed the DC to again conduct inquiry without further cause, because the inquiry ought to have been done first. At paragraph 9. The liquid commission is directed to initiate from page 73. Actually, this is page 73.
Mm.
It was directed to the deputy commissioner to initiate steps as per the provisions of law after exercising proper survey and verification. Now, this was not done before the deputy commissioner when the eviction proceedings was going on. And
No, the thing is that you have challenged the eviction order before the appellate authority.
Yes.
And appellate authority will only decide the legality and correctness of the order of eviction,
Yes.
and whether he can issue such direction to the deputy commissioner.
And that is what I'm also raising it's around my petition. Again,
No, even if he has issued such order, how prejudice is caused to you?
now, the direction was to conduct a survey and verification.
Because before the appellate authority, the issue was the correctness or otherwise of the impugn eviction order.
Yes.
So even if he is passed rightly or wrongly any such direction to the deputy commissioner, how prejudice is caused to you?
Because the one of the grounds raised before the appellate authority that the inquiry ought to have been conducted because of this schedule. But they have still only mentioned the quarter number.
Hmm.
Now, as per the act, the schedule have to be specified. As per the Also, I will be able to provide the judgment Gauhati division bench. Schedule has to be provided as to which part of the area of the land government is trying to seize or trying to take back. That has not been provided. So the submission was that under section 6, I believe, there is a provision for the DC to, before passing the eviction order, to inquire, conduct inquiry, conduct survey of the land. That was not done. So that was raised.
No,
But
you see,
the rest-
you have admitted in your several application that the quarter was allotted to you.
Yes.
And you have been occupying it. Now, where is the question of entering into the inquiry to decide whether it belongs to the government or not?
Not on that, the schedule of the land.
Hmm.
Not on the whether it belongs to the government,
Mm.
but the inquiry will be regarding the schedule of the land. In possession of the petition.
Hmm.
It has made the direction was given, pursuant to which, without conducting the verification, subsequent eviction notice was also issued, which has also been duly the next match. I'm just highlighting the due notice.
Okay.
Lordship, the citation submitted by the petitioner. So maybe reported I verbally objected because there is no relevancy at all. The effect and circumstances of the cases, proximity of the effect and circumstances that the refer case and the present case is quite remote. So that may be reported that I verbally objected that it is not applicable in the present case.
Okay, he has not yet produced the decision. You can produce it to furnish to the court master.
My
If possible, during the course of the day. If not possible, by tomorrow morning.
I have the books.
Okay.
My objection is written.
Okay. Heard Mr. L. Iralo, learned counsel for the L or I.
For the petition.
You are for,
Petitioners.
no, that's all right.
Yes.
Your name is L or I?
L. Irani.
L. Iralo, learned counsel for the petitioner, and Mr. I himself, learned additional lazy for the state respondent. Argument concluded, judgment reserved.
Also, the point of view that the petitioner being at the petition expired and is represented by his class.
Petitioner expired.
Why isn't it?
Okay.